Ciao a tutti. We heard from TX Lady 817 that the Banfield verdict is coming in at 5. So we thought we would start by going over there and hearing the verdict, and then I can do the recap of Caneiro. I'm not even going to ask you if you think that's a good idea, because I cannot imagine that any of you are not interested in that verdict also. So since it's coming in at 5, we'll probably go over there right now, and then we'll come back here and I'll do the recap. And thank you again, TX Lady 817, for keeping us informed. You know, a good YouTube channel needs a community, and I have a wonderful community of proffers. So thank you, TX Lady, and thank you all of you for all your help and support. Oh, and we are there. I said we're going there, but we are there. I just looked up. I was looking down, not up. Okay, well, let's see. Come on, come on, come on. 5 o'clock. We want to hear this verdict. So they were out about 3 hours on Friday. They came in at 10 today. They must have announced around 4:30. So 10 to 4 would be 6 hours minus lunch is 5 hours. They might have taken a break or two. So let's say 4.5 hours. So it's probably maybe 7.5 hours that it took them to decide, and we will hear. I think it was not an easy case for him before he got on the stand, and then he got on the stand, and I think he made things a lot worse. I watched some of his testimony, and then I watched a little more in, a recap review that night. And I actually thought he did better on the stand than virtually everybody else did, but I didn't think he did well. I just thought he did better than a lot of people. Some people said he reminded them of Charlie Adelson, and I didn't think he was that bad, which is not saying a lot because that was a pretty low level. And I mean, the story was just crazy, but come on. See, now they're late. I mean, I'm on a tear about judges that are not timely. And I'm just going to have to, tonight, I think I will have a nice glass of wine to calm myself down, because it's just, it's wearing on me that they are not as efficient. And this judge in Caneiro, as you know, this is New Jersey, where things should be fast and, crisp and a little rude. And we're not doing crisp and fast. We're doing, sort of casual. We ended, for those it's just, I'm glad I'm not a taxpayer in that county, although I've said before, I'm sure my New Jersey taxes in some form are going to pay. Here we are. The officer's pretty close to him. The officer thinks he knows what the verdict is. He really does think he knows. Look at him. And the defendant doesn't look too happy either.
All right. And juror number 9, you were the foreperson in this case, is that correct?
Yes, Your Honor.
All right. And are these the verdicts of the jury?
Yes, it is.
And are they unanimous?
Yes, it is.
He looks sick, doesn't he?
In criminal case number FE 2024-666, count 1, we, the jury on the issue, join in the case of the Commonwealth of Virginia versus Brendan Robert Banfield defendant, find the defendant guilty of aggravated murder of Joseph Ryan and Christine Banfield as part of the same act or transaction. Case number FE 2024-666, count 4. We, the jury on the issue, joined in the case of the Commonwealth of Virginia versus Brendan Robert Banfield defendant, find the defendant guilty of aggravated murder of Joseph Ryan within the same 3-year period during which he did also kill and murder Christine Banfield. In case number FE 2024-666, count 5, we, the jury on the issue, joined in the case of the Commonwealth of Virginia versus Brendan Robert Banfield defendant, find the defendant guilty of using a firearm in the commission of a felony. In case number FE 2024-873, count 1, we, the jury on the issue, joined in the case of the Commonwealth of Virginia versus Brendan Robert Banfield defendant, find the defendant guilty of child endangerment.
All right. Would either side like the jury polled?
Yes, Your Honor.
All right.
Members of the jury, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Juror number 2. Juror number 5.
Yes.
Juror number 9.
Yes.
Juror number 10.
Yes.
Juror number 12.
Yes.
Juror number 19.
Yes.
Juror number 22.
Yes.
Juror number 25.
Yes.
Juror number 28.
Yes.
Juror number 32.
Yes.
Juror number 34.
Yes.
Juror number 37.
Yes.
Thank you.
The court does find that the jury verdict is unanimous at this time. Ladies and gentlemen, this completes your service in this case, and I know I speak for everybody that we thank you in this difficult case for all the time and attention you've taken to it. I do need you to go back to the jury room for one more time, and I'll be back there in a few minutes just to talk to you before you leave, okay? All right, so you're excused to the jury room. Thank you.
It's nice that judges do that now. They didn't always in the past, because the jurors have given a lot of time, and, you know, they deserve to be thanked personally by the judge. There's the father, and I think the stepmother are sitting there. I mean, there's no
Mr.
joy in
Banfield,
any
in
of
accordance
this.
with the jury verdict, I do find you guilty of aggravated murder on count 1 of 2024-666, and also count 4 of 2024-666, and count 5, commission of a felony with a firearm of 2024-666. Also, on count 1 of 873 of child endangerment, I do find you guilty as found by the jury. Do you wish to have a pre-sentence investigation report, Mr. Carroll?
Yes, Your Honor.
All right, I'll order a pre-sentence investigation report for this case. What date did you want to set this for?
I don't know what dates you would have available.
I could set it for, do you plan to have victim impact statements, I
Yes, ma'am.
assume, and testimony? I mean, I could put it on, well, any day before July 1st.
Understood.
I'm retired then, so let's pick, is April far enough for you, Mr. Carroll?
Your Honor, may I just look at my schedule?
Sure.
Would there be a particular day?
April 17th is my sentencing day.
Okay.
Judge, that is the one day in April we would
You
not.
can't do, okay. Well, we can make it a different date in April. I mean, I do have March 20th, but that might be too quick.
And April 17th doesn't work for you? Tom?
No,
No,
but
unfortunately.
if you don't
We do-
want to go to, I mean, we could go to May 8th. I have May 8th available, or I could make it any Friday that you want to go to in April, if that's too far for you, Mr. Carroll.
May 8th is available, Judge. It's only 2 weeks away from April 17th.
Okay, May 8th.
That's fine.
All right, we'll set it for sentencing then on May 8th, and we have the pre-sentence investigation report by that time. And if you need it for a special time, just let me know if we need to move it from the
Yes,
10
ma'am.
o'clock time.
As soon as
Okay.
we've had a chance to speak with
All
the
right.
witnesses and the victims' families.
All right, anything further for this matter at this time?
No, ma'am.
Okay, thank you all.
Thank you.
Thank you, Judge.
That was short and sweet. it's quite the, when you stand up there and you think you're going to spend the rest of your life behind bars, no freedom, no autonomy, no ability to decide, hey, right now I'd like to go have a, Coke. Let me go to the refrigerator. Boy, it's a pretty day out. Let me go out and, sit on the porch or take a walk or play ball, and that's what he did to himself. And, I'm not, no sympathy because he murdered two people, one of whom, well, both of whom were innocent, but one of whom had no connection to him whatsoever. He was just sort of like the pawn or the mechanism by which he was going to get away with murder. So it's just awful. When you think of the lives that have been really, I'm not going to say devastated by it because that gives him too much credence that he's able to do something that's going to destroy lives forever, and I don't want to do that. But he certainly has done damage to his daughter, certainly to his wife's family and friends, to his family, clearly to himself. It's just awful. Awful. Okay. All right. I don't know that anybody in the chat has something that they'd like to say about this verdict. It really wasn't a surprise. The thing that I don't like about it is the deal that they gave the au pair, Juliana. Is that what her name is, Juliana? I mean, I think she got a sweetheart deal that she didn't deserve. She was actually the person who fired the kill shot on Joseph Ryan, who only, went to the house. I mean, he was there for kinky sex, but, kinky sex doesn't mean that you should be murdered. And yet she's getting time served. It's a travesty that she's getting away so lightly. And I don't believe for a moment, frankly, that because she was 23, 24, that she got talked into it and has no culpability because she was young. I don't believe that for a second. But she's got a really good deal out of it. Okay, and again, thank you very much, TX Lady 817, which I'm finding out here, your name is Dawn, hidden behind TX Lady 817, who doesn't live in Texas, I found out earlier today, and all her relatives are in New Jersey, I found out today. How many guilties was that again? Well, it was murder of the two victims, child endangerment, and there was, I think, a fourth count. Somebody remind me of what the other count was. I don't think there were 5. I think there were 4 counts. So, okay. All right, let's move into it. Yeah, it was a terrible deal. You're understating, Jeremiah. Terrible deal. I was gossip, rumor, innuendo, who's been following that trial, said she really believed that without the testimony of the au pair, there wasn't enough evidence to convict Banfield, and so they had to do it. But boy, it's just a terrible thing. But at least she'll go back to Brazil. She won't be here, maybe preying on others. I mean, let's not talk. Just terrible case. Okay, so can Joe? Let me see this. Can Joe Ryan's family sue her and Brendan for wrongful death? Yes, they should be able to sue both of them. The issue with her, and I hope they take care of it in the plea. Those Slayer statutes generally require that you have to be convicted of a crime where you had the intent to kill. And her plea deal got it down to manslaughter, I believe, with time served. And I didn't look at the New Jersey statute to see whether manslaughter is the intent to kill, heat of passion or something. Because if it's not, she can profit from the crime. And apparently she's talked to one of the, I don't know whether it's not Netflix, but somebody's talking to her about doing a documentary and paying her. And I think that would be even more of a travesty. So I hope that in the plea, they do something to prevent her from profiting from the crime. And that if she, she shouldn't be able to do it at all, but certainly not let her profit from the crime. Let the money go to the kids or to charity if she gets anything. but she is talking to them about doing it. And who knows how much of what she said was true. I mean, I think her story was closer to the truth than his by far, but she downplayed her culpability. I mean, she did say that she shot Ryan in the head because he was moving around. But I think she still downplayed her culpability, and she really got a good deal. And it would be really a travesty if she can now make money out of it. Imagine if you were a member of Joseph Ryan's family, or of, the grandparents, the parents of his wife, and now you have to see that the au pair who had the affair, living in the same house, and then participated in the murder, is going to be able to have a show and make money and probably be looked at sympathetically in the documentary or the whatever they do. It's terrible. I would hate it. So, okay, let's look at the trial that's still ongoing, because it's never going to end as far as I can tell. There were 4 witnesses today. They were all from the New Jersey State. They were all officers of the New Jersey State Police, and they were all forensics specialists. And the first one was Allison Lane, and Allison Lane talked about, she was an expert in fluids, the science of serology, and it's really blood, semen, and saliva. And basically what she talked about was blood, and the testing that she did on blood in the laboratory. What she did was she did a presumptive test on some of the items that were given to her, and some of them showed in the presumptive test positive for blood. That doesn't mean that there were blood, because you have to go on then and do other tests. But some of the items were not positive for blood. And we can see her there, very serious demeanor. She laughed once at something that the judge said, but otherwise she was all business. I thought she was very good. I thought all 4 of the experts today were very good. And I have said before that I think the law enforcement, the people from the fire department, and all the collectors of the evidence and all the forensics people have been uniformly great witnesses. Makes you proud as a taxpayer in New Jersey that the state police and the state lab is so well run, and that the people there not only know their jobs but know how to testify. So they were all great, and the 4 today lived up to what the others have shown. Very, very, very professional witnesses. So she did the blood sampling, and she talked about how not everything is sent over to the lab, because the people who actually do the testing of the final testing, you only have so many people, you only have so much money, so you have to make judgments about what to send over. You keep it in case later there's a decision that something else needs to be tested. It could be that further investigation points to a particular piece of evidence that you didn't send over the first time to be tested. And so she talked about what they do is they'll take a sample from what they have. So if it's jeans, they'll cut a piece out of the jeans that has the blood on it, wherever the blood is, but leave some of it on the jeans. And that's obviously so you can do more testing. You don't want to be in a situation in which you need further testing, or something happens with the sample, some untoward event, it gets lost, it gets destroyed somehow, and you have to go back and you want to retest, and now you don't have anything left that you can test. So they always try to take as small a sample as they can do in order for the next rounds of testing to be done, and then retain the rest of the evidence. Also, if there's a retrial, or maybe, it turns out that they've got the wrong defendant, and then they go out and they find somebody else, you've got to have enough of the evidence left to be able to do the testing. Otherwise, the defense will say in the later prosecution that they were disadvantaged because the evidence doesn't exist, and they wanted to do their own testing and they can't. So anyway, she talked about taking the samples and then making some decisions as to what to send over and what not to send over. And then she also talked about how they retain the rest of the evidence and secure it. The second forensic expert was Christopher, and I think he pronounced it Zinkowick. I know if I'm messing it up, I apologize to him. He was also very professional. He had a habit of moving his head that was a little distracting, but he knew his stuff. And again, very, very good witness. And he talked quite a bit about how DNA, how they make, how they test DNA and what they look for, and how they make judgments about whether there seems to be a comparison between one person and another. And he was really, I think, also very, very effective in what he talked about with regard to what he did. And then we had Christine Schlenker, who was a DNA analyst, and she took some of the items that had been sent over by Allison Lane or by Christopher. I don't want to try his name again, but you heard me the first time. And she talked about what she then did with some of the evidence. And Teresa Nezezin was the final forensic expert. She also worked with the DNA in trying to identify whether there was a match. And there she is. She, as compared to the first witness, Allison Lane, was much more relaxed. She smiled a lot. Also very professional, but she smiled a lot. She wasn't so serious about everything. But she also did, as I've said, a good job. And they tested items from both of the houses, both Paul's house and Keith's house. The same expert in the lab tested for both. And there's the first witness, Allison Lane, looking at the genes. And you can see all those little, looks like little Post-its. And those were the places where she actually took a sample. Looked like blood. It was, sort of a rust red color. And those are little places where she took a little sample in order to do the presumptive testing, and then also to decide which of those items, if it presumptively tested for blood, to go to the lab for further testing to be done. And so they took, there were knives that were taken, both from Paul's house and Keith's house, a glove. They talked about a pile of stuff that included blue jeans. And if you remember, that was found. One of the early police witnesses talked about finding a pile, and it was all scorched and wet because of the hoses that had come into Paul's house, scorched in a pile. And then they said, some of it was kind of glommed together. And she talked about having to, sort of separate everything out and then decide what to test for. They took scrapings from Paul's house in the kitchen, on the door, the entryway door, and a couple cabinets, I think a place on the island. And they also had patterned blood from the 4 victims: Keith, his wife Jennifer, Sophia, the 8-year-old, and Jesse, the 11-year-old. Those were their matches. So when they were trying to decide, when they had the blood and they were trying to do a DNA match, they had the control samples of each of them. And one interesting thing they talked about, the last witness talked about, was that Sophia's blood had a, I want to call it a glitch. I don't have the I'm sorry, I got disconnected here. Let me back up. So they had the 4 masters, or the control samples, each of the 4 in the family, so that when they were testing, that was the control they could use. And they talked about Sophia's blood having a mutation at one of the loci or loci, the locations in which they test. They tested 27 different places if they can. Sometimes they don't have, the blood sample doesn't have all 27 because the blood sample is not a perfect sample. Water can dilute it. The fire could have had an effect. They might not have been able to pull enough to test. There are all kinds of reasons why it could happen. But what they said was, which I found very interesting, is 99% of the DNA that I have, that you have, that anybody else has, is going to be the same. And that's why we all have eyes, we all have fingernails, we all have lips, we all have hair. It's all the same. It's that last 1 or 2% that differentiates, so that I'm not you, you're not me. We're not all, we're snowflakes, not a mound of snow on the ground. And there, to determine the places where we're different, they look at 27, as I said, 27 locations. And what they look at for is sequencing and repeat patterns. So if you use A, B, C, D, they want to see how often that particular pattern shows up. And that is the way that they can identify me from you. And Sophia had a mutation in one of those, which is really interesting. I think the state may, in closing, make something of it. You can't make a mistake with hers because she's got that distinct difference. And if the blood shows it, it can't be anybody else in the family. It's got to be she. So anyway, it was the genes. I think might have been 2 gloves, but it was at least 1 glove that was tested. And Sophia's blood was a match for 2 or 3 places on the genes, which we're going to find out, I'm sure, are Paul's genes, or at least identified as Paul's genes. These are the ones that were in his house. I think Jesse was a match for 1 place on the gene. Sophia's blood was also a match on the knife handle, maybe also on the blade. And is this where it's showing us the mutation? I don't know if it shows us the mutation, but it does show the way that they do it. If you look at the first, you see those little, what did they call? They didn't call them mounds, but each of us has DNA from both parents. So father and mother. And if that's why you see under that first one where the X is, you see 2 numbers under it. 1 is mother, 1 is father. If you go down that line far enough, you see one that has 2 mounds. They didn't call them mounds. I'm sorry. They called them something else. And that's when you may have mixed blood. And then you have to figure out, it's harder to do with when there's a mix. The defense tried to make a point of, if you've got family members, then it's harder to distinguish which family member, because they are going to have blood in common. They're going to have markers in common. And maybe that makes it harder to identify whether the blood is mixed or not. And the expert witness was not going there. She said, if you only see it in 1 place, peaks. Thank you, Christine. I knew it wasn't, peaks is a nicer way to put it too. Yeah, peaks. And she said, if you only find it in 1 place, it's not mixed. It's not 2 different contributors. You have to then see it repeated other places to draw that conclusion. Defense lawyer tried to get her to agree with him that isn't necessarily what it meant, but she really stuck to her guns. And he, unlike the female defense lawyer, who I don't want to know her name because she really annoys me, didn't keep trying and trying and trying and trying to get the expert witness to say what he wanted her to say. So, but he obviously was making a point that since Paul and Keith and Corey are all brothers, that it's harder to identify or to be sure that you're doing it correctly when you say it's Paul's blood and not Corey's blood. He also went after, they've got a new tool that they can use when they're trying to do DNA analysis, and it's called, I have that written somewhere. I kind of like the name of it. It was called, let me see. I wrote it somewhere. I'd find it quickly. And of course, I can't find it quickly, even though I wrote it so I would find it quickly. It was called somebody in the, there you go. Thank you, Star Mix. I wrote it, and I wrote it in big letters too. I'm sure when I look down, I'm going to see it jump at me now. Star Mix. And he clearly tried to undercut what Star Mix actually shows. And I think what he is going to do, he did get a question in about Star Mix is only as good as the input. The information you give it is going to predict what comes out. And yeah, quote me for saying something snarky and saying you liked it. Thank you, Jeremiah. But in any event, it's pretty clear, I think, that he's going to go after the Star Mix tool. I'm calling it a tool. I don't know that she called it a tool, but it doesn't do its own. You can't, the analyst relies on it, but it's the analyst's decision with regard to it. It's not the Star Mix that, it's not like you push a button and you get the answer and it tells you everything. The analyst has to then exercise her judgment or his judgment in evaluating. So what came out clearly, I think, from today is one, they're going to challenge Star Mix. Two, they're probably going to challenge you sent this sample to the labs to do more testing, but you didn't do those samples, and there might have been something in those samples that would have exculpated Paul, or more likely what they want to say, incriminated Corey. And in fact, they had a question right at the end of the day in which the defense lawyer asked whether it could be Corey's DNA, and there was an objection to it. The judge allowed the question, and then they went sidebar, and then we finished for the day. So I don't know whether that had anything to do with finishing at 3:30 or not, but we did finish for the day at that point. So, but I do think they're going to challenge the DNA analysis because of Star Mix, also because since they're brothers, that there was a risk that the analysis is misidentifying Paul when it's really Corey, or at least you can't tell which it is. I don't think they're going to succeed with that for a couple of reasons. There were people in the chat today and last week also who said repeatedly that defense lawyers go after the DNA experts, but they can't recall a trial in which the defense actually won by challenging the science of DNA. But these defense lawyers seem to be walking down that road. They obviously are going to try to keep pointing the finger at Corey, not necessarily to demonstrate that Corey did it, but to raise a reasonable doubt as to whether there's enough evidence to convict Paul beyond a reasonable doubt. Let me see if there's anything else in here that came up today. I don't think so. Are there questions in the chat? Because those are the things that I thought were most impactful today. I did find it interesting, and I mentioned it this morning, that it appears, we haven't heard everything yet, but it appears as though the blood that's going to most tie Paul to the crime is coming from the 8-year-old, who of course had the least amount of blood in her system. So it's kind of I don't know, almost a sweet irony, since he went after those children, that the littlest of the two children is the one that may be the person whose evidence convicts her uncle. But that was mostly today. I don't know that there was anything else. If you've been watching the trial, that the prosecutors do a very good job. They do a great job laying foundation. My objection is they do too much, and they do it with every witness. I complained today. Today was my day. I mean, I complain anyway, but today was really my day to complain, because they asked the first expert witness, what does it mean to have peer review of scientific work? And so she explained. And then they asked the other 3 experts the same question, what is peer review? Now, if one of them tells you what it is, You do not have to elicit that testimony 3 more times. The jurors are not idiots. They can hear it. So that's really maybe one of my 2 major complaints. It probably is my major complaint with the way the state does the case. And, in the great scheme of things, it's not much of a complaint because they really are doing a first-rate job of presenting the evidence in a clear, coherent, logical fashion. The other thing is I wish they would object to the repetitive questions, but that one, although it's very annoying, and we all know that it's very annoying, just keep that question up until I can get to it so I don't forget what it is. Thanks, Amber. And it's very annoying. I do believe that the prosecution has a motive to its madness, which is it's driving us nuts watching, and we all can get up and get a cup of coffee or walk around or decide I'm taking 15 minutes. Not me. I have to be here. But the rest of us can get up, and take a walk, get a cup of coffee, go outside and scream because the thing isn't moving more quickly. The jury can't. And I'm positive the prosecutor thinks that she in particular is driving the jury crazy. And why should he get involved and let her and not have her annoy the jury as much as she's annoying the jury? So even though it's very annoying to me and I don't like it, I have less of an objection about it because very clearly it's a purposeful decision. In fact, it's a purposeful decision the judge doesn't like, and they're staring the judge down and not making the objections he wants them to make. He seems to have given up because he hasn't been pushing as much. I guess he's decided 2 things. I think he may have decided he can't make them do it, so why continue to try? And the other thing is, I think he has thought about how his exasperation is what impact it's having on the jury, because the jury looks up to him. He's very friendly with them. He's the power figure in the courtroom. And if he appears to be unhappy with the defense, and from that they infer that he thinks the defendant is guilty, it may have an impact on them. And it certainly creates an appealable issue. So I think he's had a second thought about doing what he did in the first few days. And he also actually did an instruction to them last week saying, hey, this is a good time to remind you what I say is not evidence, what the lawyers say is not evidence. You shouldn't infer from anything I do or say because I'm supposed to be objective. And that helped with the record on appeal. So I think that may be why he's just tempered. I don't think he's any happier about it, but I think he's trying to control his reaction to it. Okay, now this sentence, Charlie Delta Whiskey. The judge sentenced Juliana to 10 years. The judge, now we're back to Banfield. When the prosecutor offers a plea deal to a defendant, some jurisdictions say you can't force the judge to accept the plea deal. You can't make the judge sentence. I think that's true of all jurisdictions, but jurisdictions differ. In some of them, if the judge does not make good on the prosecutor's part of the deal, in other words, it appears as though the prosecutor said time served is what they'll recommend. The judge doesn't make good on it. Some jurisdictions allow the individual to pull out of the deal. So you can't use the guilty plea. You've got to pretend she didn't say she helped. You got to pretend she was not complicit, and she then can be prosecuted. Other jurisdictions say you warn the defendant, hey, this is what I'm going to recommend, and I'll urge it as much as I can, and I'll say you cooperated, but I can't bind the judge. And you have to realize that there's a risk that the judge may say, I don't care what their deal was. I'm going to accept the guilty plea because you pled, but I'm going to impose a more serious sentence. So some jurisdictions do that. I don't know what Virginia does. So the judge, I think, has the authority to sentence to more. Whether she'll do it, I think is a much bigger question. And then the other question is, if she does do it, can Juliana pull out of her side of the deal? I can't, it's hard to believe that she would, because they now can prosecute her. And I don't think she wants to go through a prosecution. So who knows? But so the theoretical answer is yes, but I'm doubtful that the judge will do it. Okay, this is from Jeremiah McGee. What more does the state need to do before arresting? Do they still need to address the 2 unknown men as mentioned by the neighbor? Well, they still haven't, I don't think they've tied up the ballistics yet, have they? Which bullets, which guns. At least I don't recall that's happened. So they may still have a ballistics expert to call. I don't know that they have anybody else. I mean, once the DNA, well, they may have more DNA evidence they may have another expert. There may be more that was tested that we didn't hear about yet. So I don't know who else that they would have at that point. It seems to me they've gone through everybody. This has really been a case of the experts. I mean, we all know how many times the judge has given that instruction about expert testimony. He even skipped it once and said, I'm just going to just summarize. And then he also skipped it once. And then with the last witness, I think the defense at sidebar said they wanted that instruction given again. And then he gave the full instruction again. And that instruction says, mostly witnesses can't give an opinion. Experts are allowed to offer an opinion because they have special expertise and their opinion may assist you. But you have to remember, it's your job to decide the facts. You do not have to accept what the expert says. You can go ahead and do something different. It's your job, not the experts. And I think he did that full instruction for that last state's witness today because the defense asked for it after they went to sidebar. Christine's asking about the medical examiner. And unless I made this up, unless I'm becoming AI and having these hallucinatory moments, I thought that there was already evidence about where the knife wounds were and smoke inhalation. Maybe it's just, sometimes you read all this stuff outside the trial and think that it must have happened during the trial. So do other people in the chat remember that? If in fact that didn't happen, then probably the medical examiner will testify. But I really thought, excuse me, that some of that came in. And I don't know, I had questions in the chat before about whether the state will call Corey, and I can't imagine why the state would call Corey. This is the defense saying, hey, look over here, look over here, look over here. And the state is saying, hey, look at the evidence. You don't have to look over there. Look at the evidence. He's the one who had the fight. He's the one that was playing around with the money. He's the one that wasn't paying the premiums. He's the one his brother was very angry with. He's the one where his brother told him, I want out of these work relationships. He's the one whose jeans have his niece's blood on them. He's the one who would know where the cameras. Now, Corey could also know that, I admit. But he's the one, trying to think what else. There's other evidence in there from maybe the insurance agent that we heard right at the start, or the accountant right at the start, about having talked to Paul about some of this. So I don't see why the state would try to monkey it up by bringing Corey in to say, what, I didn't do it, and allow the defense then to cross-examine him and point, even more firmly at him. So I don't think that's going to happen. Seems to me they should be nearing the finish line, but I don't know how many other experts they think they need to call. And then for the defense side, I don't know what they're going to do. I can't imagine that Paul will testify. And I don't know who then they would call on the defense side. Now, the other question was the 2 men. I don't know what the state will do about that. Was the 2 neighbors who said they saw the 2 men. A lot of cases aren't perfect. They're just oddities. And it's because life is not perfect. It doesn't read the way you can write a story where every little piece fits. There are just these odd things that don't quite fit. The defense tried to make a lot out of the neighbor, Keith's neighbor, who heard the gunshots. It seems as though he did hear the gunshots, but you can't prove it. He might have heard other noises, cars backing up or backfiring, even though it's an odd time of night or early morning, I admit. But you can't know for sure that those were the gunshots. And so I assume that the defense is going to make a point out of there was only a minute, and she's going to say 1 minute again, even though the witness said I never said that. So I really don't know who the defense might call. As I said, I don't think they'll call Paul. You can't call character witnesses. You can't call somebody to get on the stand and say, gee, he's a really nice guy, would never do something like this. That's inadmissible. It's hearsay. And in fact, if you do that, then the state has the right to call character witnesses to say, no, he was a bad guy. So it's not something that the defense is likely to do. So that's the best I can give you. I don't, I didn't watch this case way at the beginning, and I've never seen a witness list, and we've tried to find a witness list and haven't been able to, locate one. It should have been posted on the docket, you would think, but I haven't seen it. The witness list might help a little to try to figure it out, but we haven't seen it. So, other questions? I don't see anything over here. All right, let's see. Looks like that's it. You all you chat a lot and you have comments and points of view, which I admire and like, but not as many questions on this one. Okay, well, that's fine. What was I going to say? Okay, so tomorrow, what we're going to do here on Prof Jo Explains is we will start at 8:30. With this trial, whenever it is that Charlie's oral argument will be heard. And as I've said before, I had the docket sheet which said 9. I've been told by a couple of people that it's 10. Joel Waldman on STS thought it was in the afternoon, and I haven't seen anything really firm as to when it is. When we know, we will post clearly and get that out, and so will Court TV, and I'm sure STS will do the same thing. So it will be a lot of places, being conclusive about what time. And whenever it is, I'm going to move from the trial over to doing the oral argument and then come back to the trial. Right now, what we're planning to do, things may change, but what we're planning to do is leave the trial stream open. So if there's a person in this world who has no interest in Charlie's oral argument, which I frankly very much doubt, but there might be somebody, that you can stay and watch the stream. There won't be anybody here commenting, but you can certainly stay and watch the stream. I don't know yet whether we will co-stream so you can come back in on Prof Jo Explains and watch it and I will comment, or whether I will just do the commenting for STS and we won't have a co-stream on it. Joel and Tim Jansen and Steve Cohen are going to be at the oral argument, so none of the three are going to be able to comment. Whatever happens, whether I do Prof Jo Explains or not, I think I'm going to be commenting for both STS and Prof Jo Explains as to that oral argument. Then, as I say, we'll come back here and do more of the trial. And what I'll probably do on this end is maybe at lunch or whatever, I'll take questions on, what was going on in the oral argument. At 5 tomorrow, I'm not going to do a recap of the trial. What I'm going to do is, let me get his name. I don't want to get his first name wrong. Chris McDonough of the Cold Case Foundation, who's been following Caneiro, so he'll, I'm sure, have some comments about Caneiro. But he also, as I said, chairs the Cold Case Foundation, and they're the people who go out and open cold cases and ultimately track down who the murderer was many, many years later. Allison Galvani, who had the channel for My Father's Alibi. Her father, that was 35, 40 years ago, and her father was just arrested recently. He's having his bail hearing sometime February, must be coming up pretty soon. And that's an example of a cold case. There are other cases where many, many, many years later, the police will go back. They'll keep looking at it. They'll keep looking at it. DNA and the advances of DNA have helped a lot with cold cases. And that's another example about keeping evidence, not getting it all destroyed while you're testing the first time. So if later evidence comes up and you want to go back, you've got in the vault, you've got, the information from which to then build the case. Anyway, he's very active in that, and we'll be able to talk about how you how you go back, what the kinds of things you think about when you're trying to think about, can we reopen a case, and the kinds of things that are done so that law enforcement can say, this is one where we really think we can pursue it now. So anyway, he's going to be on at 5 tomorrow. And then don't know whether I'll be doing anything. I don't know whether I'll be doing STS. I'm not sure. And then Wednesday, we will have back on someone that I had on a few weeks ago, Chris Gramaccioni, who was the prosecutor in Monmouth at the time that the murders happened and the arsons happened, and he can't talk about the case itself because he was the prosecutor at the time and he's bound by confidentiality. But he's a very good lawyer, and he also knows the area and the way prosecutions get put together. And I think he will be commenting again about where Caneiro is now and what he thinks will happen next. So that will be Wednesday. And tonight at 7, let me say about STS, I said I'm going to be on, Tim Jansen is on, and also Dave Ehrenberg, who was the chief prosecutor, the DA for, I don't know whether it was the county that includes Miami or the one just contiguous to, but he knew Dan Markell and has been following the case. He's the one, by the way, so you may not want to trust anything he says tonight, but he's the one who said a couple of months ago that he thought within a month Wendy would be arrested. And of course, that prediction didn't come true. So if you watch tonight, you may put in a question and say, you said 1 month, now what's your prediction, and see what answer you get. Any other questions? Otherwise, I think we probably should, go off and you can go have dinner or whatever. Let me just check to see if there are any other questions here. Nope, I think that's it. Okay, well, have a good evening. For those of you who stuck with the trial today, I admire your fortitude. I do. I probably found it more interesting than some of you did, because I don't mind the technical stuff that the experts provide. I always feel as though I'm learning something. I mean, I didn't know that 99% of all our DNA is the same, and it's only the 1 or 2% from which we have our differences. That to me was just kind of a really interesting piece of information. I did not know that for scientists, source has a technical meaning, and source means if they say you're the source of the DNA, it means the chances that are not you are astronomically limited. So source doesn't simply mean, some of your DNA may have been used. It means this is really a lock. I didn't know that either. So I learned 2 things today, and I love it when I learn something new, and I learned 2 things today. I was cranky today. If you didn't hear me today, I'm always a little cranky, but I was really cranky today because it seems to me that this trial should be 3 days farther along at least than it is. Now, I'm not going to fault them the snow day, but we've had 2 days off in addition to the snow day, I believe, and 5 minutes here and 10 minutes there. longer lunches, longer breaks, ending at 3:30 most days. You know, it's a travesty. So, okay. I will say ciao a tutti and have a lovely evening. And I will see you tomorrow.